Live from the offices of Great River Investments in the beautiful city of Burlington, Iowa, this is the Marvin Knows Finances show. I am your host, Marvin Thomson, your certified financial planner, and joining me today is Joe Jolan of Jolan Media in West Burlington, Iowa, Todd Sladky, CPA, and my partner, Great River Investments, and our special guest today, Attorney Mio Santiago of Kozlowski Law Group in Burlington, Iowa. Thank you for taking a few minutes out of your day to listen in, and for all you listeners on Google Podcast and Spotify, don't forget to click the subscribe button. If you prefer to see how we make this show come together, please check out our YouTube channel, Marvin Knows Finances, and click subscribe there as well. Just like the last and every time, I have to take care of a little business before we get moving too far forward to please my compliance department. Marvin Thomson is an investment advisor representative and a registered representative with Brokers Financial member SIPC. Opinions expressed in this program do not necessarily reflect those of Brokers Financial. The topics discussed and opinions given are not intended to address the specific needs of any listener. Great River Investments, LLC does not offer legal or tax advice. Listeners are encouraged to discuss their financial needs with the appropriate professional regarding your individual circumstances. So, gentlemen, welcome everybody. Thank you for being here today.
Good morning.
Thanks for having me.
How y'all doing?
We're doing great.
Good. Well, everybody ready for the holidays?
No.
Yeah.
No? I'm right there with the no group right there. So we're going to start out as we usually do with our question of the week. And the question of the week, of course, is tying in really nicely to our topic today, which is estate planning basics. So the question of the week is, do I need an estate plan? And if so, what does it entail? So when Todd and I always do our financial planning work with our clients, we definitely focus a little bit on the estate planning piece of it, okay? Obviously, we're not attorneys, so we don't delve into it, but we do ask the questions about the wills. We do ask questions about the power of attorneys and so forth. And Mio was kind enough to join us today to hopefully make this topic a little bit more clearer. So, Mio, would you like to start out by giving some background about yourself and the law group and where you're located at and how they reach you?
Sure. My name is Mio Santiago. I'm an attorney here with the Kozlowski Law Group. We are a full-service law firm here in Burlington, Iowa. I practice primarily in the areas of estate planning, probate, elder law, and real estate. We are an attorney-led firm here in Burlington, and we also have a satellite office in Fort Madison.
Perfect. How do they reach you? Website, phone number?
Yeah,
things like that?
www.kozlawllc.com is the website. The phone number is 319-753-6201.
Okay. So when we meet with clients, sometimes it's funny to see the wide range of emotions that are behind estate planning and what people think of estate planning.
Sure.
A lot of times people don't want to face the inevitable
Yeah.
that comes along with this. So can you kind of explain how you address the emotions behind the estate plan when people come to you, and what do you say to them and so forth?
Absolutely. First of all, when I have a client come in or potential client come in, I applaud them just for that very fact. One's mortality is a pretty daunting topic to think about. But once you get past that, I'll start a conversation with them and say, is it important to you, when you pass, to make things easier for those you leave behind? Or do you want to leave a mess? They're already grieving for your loss, and then they have to go to the next step and figure out what happens to your stuff. Mm-hmm. And if your stuff is here, there, and everywhere, and they don't know anything about it, and it wasn't planned properly, you've just added a heck of a lot more stress on their plate. Versus if you have a well thought out and well planned out estate plan, though it's never going to be a pleasant process for them, it will be a lot easier. And probably most importantly, your wishes will be adhered to and followed.
Okay. When people hear the phrase estate plan, I really think that they don't understand that everybody technically has an estate.
Yeah.
I mean, obviously there's smaller ones, there's larger ones, and so forth. So it's kind of a dumb question right off the bat, but are estate plans only for the rich?
No. Estate plans are for people if you have any things that you want to leave to loved ones or other people. Anything. An estate, and this might go a little bit off of our outline a little bit, but how I approach estate planning, there are three pillars, and we can delve into them later. Three pillars of estate planning. The first one is what happens to your stuff. When you die, what happens to your stuff. And that's probably what sticks out in people's minds as a will or a trust. And so that's where people probably think an estate plan is. That's only one piece or one pillar. The other two pillars that people might not think about as much is, hey, that deals with death, but what happens if you've become incapacitated and can't make decisions on your own? And what really comes to mind are decisions for finances. Life goes on, even if you're in a permanent vegetative state. Someone still has to make your finances go and pay your bills and be able to make transactions on your behalf. And so that's the second pillar, what happens to or who can take care of your finances. The third is who can make medical decisions on your behalf. Who gets to communicate with the doctors, get access to your medical records to make decisions, if you're unable to do that. So, it's a comprehensive thing. It's not just, hey, my will, my stuff will go to this person. So that's why everyone needs an estate plan.
Okay. So age-wise, when should people start looking at doing this?
Once you're 18.
18?
Yeah,
really?
Once you're 18, because you have things.
Mm-hmm.
You have, you're an adult. Your parents can't make those decisions for you.
But we want to.
But would want to. And exactly. And so, to use it might be a bit of a morbid thought, no one wants to think of anything bad happening to their children. Your child gets in a car accident. He or she is, in college. The hospital doesn't have to and often won't communicate with you or let you make decisions because you have, other than being a parent, which sounds crazy, he or she is a legal adult.
Mm-hmm.
And so, that could just open up a whole can of worms if you had the wrong medical providers that really held you to that. It could be, pretty troublesome. So
even though you're as the parent, you might be covering that child on your health insurance until they're
exactly
25, 26
what
years
I was
old.
thinking.
Yeah.
My daughter will be on my insurance till she's 26.
Mm-hmm.
Are you telling me that if she doesn't have a power of attorney naming me as her power of attorney, I can't possibly make decisions for her?
There's that possibility that.
Wow.
Or even go in and get a copy of something, a claim comes through. I've experienced this a little bit, but a claim comes through and, I'm carrying that child, that adult child. And I want the record, not for any bad reason, but just, for whatever reason, and can't get it.
Wow.
Yeah.
Very interesting.
So
They're real, covered a flaw in my own plan. So
Yeah.
Perfect.
Well, pretty much once you're 18, I think, at the very least, again, using the comprehensive view of what an estate plan is, yeah, you should at least have powers of attorney in place, at the very least.
Gotcha.
It would be a great Christmas present from parents to kids.
Oh, they'd love that. Yeah.
Great stocking stuffer.
All right. So, like I said, some of the basic things that we cover are wills, power of attorneys, living wills, things like that. I want to spend some time kind of going through specifically what each one does,
Sure.
if you're okay with that. So let's start out with a basic will.
Okay.
Okay. Now, I've always told clients, look, if you don't go out and get your own will, the state will provide one for you.
Yeah. Yeah.
So let's talk about why you'd want to go out and get your own will versus what the state will give you.
Sure. You want a basic will, so your wishes are followed.
What does a will do?
A will is directions to your heirs, who you leave behind, and to the court, as to what happens to your things, what expenses you want paid upon your death, and who makes, who's the driver, who kind of guides this process as the executor.
Okay.
With a simple will, the bequests are what people would think the inheritance. The inheritance that you're giving someone goes directly to that person straight away. With a simple will, you would go through the probate process, which involves the court. It's a long process. 9 months to a year is average for a quick probate. some people, and I guide my clients to potentially avoid it because it is a longer process, and it's a public process. What people don't think, you've probably seen in the newspapers, the notices of probate. The estate of Joe Smith has been opened. Any creditor who feels that they're owed money has 4 months from the date of this publication to file a claim. That's just one piece of how public it is. I could get on the computer system, the court computer system now, and access anyone's estate that was open from, I think they went live in 2013 to present, and on my computer figure out what that person who died owned at the time of their death. You're required to file a report and inventory, which is a listing of all your assets. You list who all of your heirs are. So, just think about that. It's akin to walking down the street and someone saying, "Hey, could I take a look at your personal financial statement?" How do you feel about that?
So a couple things. So on the wills, you hear stories of people writing wills out on napkins and things like that in kind of unique situations. Right at the end, something changes. They can't get out of the hospital to go see an attorney. Are those recognized by the court?
Not usually. Those are considered holographic wills, which aren't necessarily provided. There are certain formalities that need to be followed for a will to be identified in Iowa as a valid will.
Okay. All right. And the second thing is we've had a family member die, and apparently there was a notice of an estate put into the newspaper. Okay. Suddenly this family member started receiving letters from strangers saying, "Hey, the person who died owed me $6,000. So I think this opens up a huge potential for scammers.
Yeah.
So to be very careful on that.
Yeah.
Because we've personally experienced that.
Right.
It was crazy.
And the process, and you probably went through it, is they would have to file, the creditor, the alleged creditor, it sounds like in your situation, would have to file a formal claim with the court. And that would go to the executor for the executor either to admit or deny the claim.
Yeah.
And then if you deny it, then they have to come and show their work and prove it.
Yeah. No, this was a complete scam.
Yeah.
So we picked up on that pretty quickly.
Yeah.
So, all right, power of attorneys.
Yep.
So there's different types of power of attorneys. There's financial, there's health power of attorneys, there's general power of attorneys, there's durable power of attorneys.
Sure.
Okay. So what's, between the durable and the general power of attorney, one lasts until incapacitation, right? And the other one lasts for their lifetime.
Correct.
All right. So which one do you recommend?
The lifetime.
The lifetime?
Yeah.
Which is the durable, right?
Right.
Okay.
Because if you think about, that's probably when you need it the most. You want, it's called substitute decision making. Is when you're unable to make those decisions, and you want to be able to appoint someone while you're competent to make those decisions on your behalf. You want the say. Because in order to execute a power of attorney, you yourself need to be competent. So if someone came to my office and they say, "Oh, mom wants a power of attorney," and mom's next to them and nothing is registering with mom, she's not able to sign that power of attorney.
Gotcha.
So the thought process is you do it while you're competent to prove to the world, and particularly the court, that when you were of sound mind, you consciously decided to put this other person in charge of your affairs, whether it's your finances or your medical.
Okay. So a durable financial power of attorney and a durable healthcare power of attorney.
I don't really make that much of a distinction because I don't give my clients the choice. We do financial power of attorney that upon your incapacitation, you can either make it effective immediately or upon some triggering event, such as if a physician determines that I am, or sometimes two physicians, or whatever triggering event, that it carries through through your incapacitation.
Okay. Do you almost always recommend a family member to be your power of attorney?
Not necessarily.
Okay.
Not necessarily.
There's situations with distance and mileage and
family dynamics.
For sure.
So some options are children, family members, trusted friends, trust departments of banks.
What about you? Can you serve as a power of attorney?
I tend not to if I'm the one drafting the documents.
Conflict?
Yeah.
Okay, gotcha. Living wills. Can you explain what a living will is and why they're so important?
Sure. I remember I'm a child of the 90s, I'd say. That's when I went to college. Think back, there was a court case, Terry Schiavo, a woman in Florida, who was considered, and I'm kind of paraphrasing the facts of the case, but permanent vegetative state in Florida, husband said, there's no way she would want to live like this. He wanted to proceed with end of life. Her family said no. If there's even a slim chance that she could survive, we want to try everything and keep her alive as long as we want. Went through numerous court cases, state, federal level, even I think the U.S. Supreme Court, and ultimately the husband won out. I think that point in time is when living wills became in vogue, because had she simply executed a living will, that basically a living will is a document that tells the world, I value the quality of life. I don't want to be kept alive by an extraordinary means if there's no likelihood that I'm going to survive. I don't want to live in a permanent vegetative state. And that's good enough to give direction to, who you designate to make medical decisions on your behalf.
Gotcha.
To follow and to how to proceed with that.
Perfect. So having DNR tattooed on my chest is probably not good enough?
No.
Okay.
No.
All right. Trusts. So trust is something that we hear a lot from our clients. A trust has been recommended for one reason or another. And then, of course, I'm going to just say there's two different types of trust. I know there's many different types of trust, but I'm going to say two different types of trust, revocable and irrevocable trust. So first of all, do you believe as an attorney that everybody should have a trust, or is it something that a will and beneficiary designations will take care of?
It depends, as any true lawyer would say. It really is fact dependent or fact specific to each person, depending on the size of their estate, the characteristics of their beneficiaries. So, for example, when we were talking about a simple will, once you pass that your inheritance to them, they get immediately, or not immediately, but at least through the probate process. Do you have family members who are minors? Do you have family members who are spendthrifts? Do you have family members that may have a gambling or substance abuse problem? Do you have family members who have special needs and have government aid, and an inheritance could jeopardize that? Those are some of the reasons why I get people into trust. So I always use the example, think back to when you were 18 and you came into a large sum of money, and you had access to it right when you turned 18. If that were me, I'd probably have a 91 Camaro out in the parking lot, all rusted out, held together by various compounds of Bondo and other things. I'd probably only have that and probably stories of a hell of a great time, but not much to show for it. With going through a trust, you can structure your bequest, the inheritance that you give to people on certain milestones. For example, to avoid the problem, at different ages, and you probably see at different ages in life, people have different financial priorities. When you're 18 is different than when you're 25, is different when you're 30. One technique that I recommend to clients is, I know it's hard for you to even think about it, but little Jimmy and Sally are 5 and 7. But let's do the best we can, look into our crystal ball, and maybe break up when they get their inheritance a little bit. We can do that with a trust by saying, when they're 21, they might receive a third of that, envisioning oh, maybe that's when they graduate college, if that's the track for them. And then maybe another third when they're 25, they might be wanting to buy their first home or getting married. Or 30, they're starting a family. All guesses, probably, optimistic guesses on our parts is to envision what our children's lives may look like. And as we all know, they probably take twists and turns that weren't even on our radar. But, by doing that, it kind of might mitigate some of the potential damage that they could do.
Sure.
So that's an important part. Same thing, someone who has a substance abuse problem. Do you want to give them a large sum of money, or do you want someone as a trustee to oversee that, to kind of have the discretion? And the other one that people don't think about is special needs. People with special needs who are on government benefits. If they run into a sum of money, you could jeopardize that benefit and, disqualify them from those benefits for a time, and your $20,000 inheritance to them pales in comparison to the benefits that they would have lost.
Yeah, absolutely. So a revocable trust means you can make changes.
You can make changes. I use the extreme example with my clients. As we're sitting down to sign their trust, this is revocable. You can change this at any time. You could sign this now, and before the ink's dry, you could tell me, no, I want to cancel this whole thing. And then I would just draft a revocation, and it would be
Null and void.
Null and void.
Gotcha.
Or, we sign it, and, I don't want to give Billy that amount, and I want to change that. Then we could do a codicil and change that.
Gotcha. And then irrevocable or irrevocable?
Irrevocable, it's not truly irrevocable. It is, but it isn't. It's a lot more difficult. You would either have to get court approval or approval from all the beneficiaries. But, the purpose of that is, if there's a reason that you got into an irrevocable trust, you're doing that for a reason, to devoid you of most of the control. And it's usually for Medicaid or estate tax purposes.
Estate planning purposes for sure. All right, so earlier we addressed probate.
Mm-hmm.
You've already kind of touched upon,
Sure.
What is probate, how does it work, and so
Yep.
forth. So a big question is, what assets are included in a person's estate when they die?
Okay. Anything that doesn't have a payable on death or transfer on death designation, any real estate that is owned as a joint tenant, because those would pass as operation of law.
Okay. So,
But pretty much anything else would be considered.
So an IRA, for example, would have a beneficiary listed on it.
Correct.
In most cases, it should have a beneficiary listed on it.
Right.
That does not become part of the estate
No.
because it passes outside of probate.
Correct.
Okay.
So the misnomer, not the misnomer, but the confusion that lies out there is, yes, it's not passed through the estate, meaning a judge doesn't have to approve the transfer of your IRA to your beneficiary, but it's still includable in your estate for the purposes of reporting for estate tax reasons.
Do attorneys bill on those assets that are in IRAs and stuff like that pass outside of the estate?
It is part of what the attorneys or most attorneys' fees are, because it's based on a percentage of the gross estate for the purposes of estate tax. So yeah,
Gotcha.
and that's why a revocable trust may be a good idea.
Okay, very good. So when you're setting up your estate plan, you're going to name an executor.
Correct.
The person who is responsible for settling the estate when you're gone.
Right.
All right. What are their responsibilities? I mean, it's a pretty lengthy list, actually.
It is. They're your representative. They're representing your estate, so they're contacting all of your creditors. They're working with Social Security. They're working, the general term is they're marshaling your assets, figuring out everything you owned at the time of your death, figuring out what debts you owed, working with the attorney to put together the report and inventory, tracking down your heirs, which to most of us, I know where my brother lives, and I know where my parents live, and But some families are estranged, and then we'd have to work with them. We as the attorneys would have to work with them to figure out how do we find these people to let them know that they have an inheritance. So the executor would work very closely with the attorney who's probating the estate. But yeah, it is a lengthy list of responsibilities, and like I mentioned earlier, it hangs out there for a time.
Yeah.
A quick one is 9 months to a year.
Really?
I have some that are several years in.
Wow.
So
Okay. Does the executor have to be a family member?
no,
Can it be a third party?
it can be whoever you want.
So the person you like least is the one you want. No.
Well, and that brings up a good point. So sometimes people will come in to me and say, "Well, I would just like my 3 children to be co-executors or my 3 children to be co-trustees." I try and dissuade them from that, because then there's no chief. Then there's, in my example, there's 3 people who have the same authority, and that can just paralyze.
It's not majority rules.
Not necessarily.
Exactly.
I mean, everyone has their. Even if it is, I mean, okay, then just think that's 2 against 1. Are there going to be good feelings there? So I recommend to my clients and try and persuade them, pick one. And it doesn't necessarily need to be the oldest. It doesn't necessarily need to be, whoever lives the closest. It's who's ever the most responsible, because there's a particular type of trait that someone needs to be an executor, and it's fairly detail oriented and good with follow up.
Gotcha. A big important thing is, does the executor get paid?
The executors can get a fee.
Is that listed in the will or the trust? If you're a
Yeah,
trustee,
that could be
it's
specific there, but statutorily they're also entitled to up to 2% of the gross estate.
2% of the gross estate.
Same
So
as
if you
the
have
attorney.
$500,000 estate, you could take up to $10,000.
Correct.
Okay, very good. What about costs for setting up an estate plan? I know every law firm is going to be different, but do you have like a general ballpark? I mean, so for example, we got people listening right now like, I need to update my will. I need to get some power of attorneys in place, living will, and so forth.
Right.
I know trusts are going to cost a little bit more money because of the overall process of setting them up. But
Right.
what type of fees are people looking at in general?
Yeah.
You don't have to quote your own fees. By any means.
I think a good rule of thumb, going from just simply doing powers of attorney, all the way up through doing trusts, a good range between 400 and maybe 5,000. But I mean, it could be lower or it could be higher.
If you're at the $5,000 range, you probably got a little bit more complicated estate with some needs that need to be addressed specifically.
Well, think of it, how many people have second marriages with children from first marriages, or more detailed bequests that they want to give people. So it's very, very fact specific.
Gotcha.
But yeah, I think that's a safe range, and it could go higher too, depending on the complexity.
Gotcha. When people come in to see you, we're going to ask you for your website and phone number again
Sure.
before we get off here. What do they need to bring with them? What's the process that you're going to go through with them?
Sure. I mean, the first time I meet with people, I don't like to necessarily encumber them and say you need to bring A, B, C, D, E, F, G, because I mean it could be a fairly lengthy list. My approach when I meet with people is, do they even want to work with me? Yeah, because it is a sensitive topic. You need to work with someone that you trust and that you like. So that first meeting is just them kicking the tires, and me too. I like
That's right.
to
You
work.
don't have to work with them.
Right. So I can sense if we're going to work well together. And then that's when I'll kind of give them their options of, here are the different types of estate plans that we could go down, or here are the different components. And then kind of once we decide on that, that's when we'll get into. But I mean, things that you'll want to start looking at are, past estate planning documents, past wills or trusts or powers of attorney. For better or for worse, it's a good time for them to get with people like you, Marvin, and say, hey, who are my beneficiaries? Who have I designated? Oh, wow, I don't, I'm not married to that woman anymore, or we were giving some to this guy, and so if nothing else, it's a good reason to check that out.
Yep.
So list of assets, bank accounts, investment accounts, deeds to homes, to know how they're titled currently, to make sure. So it's, part of the estate plan is kind of a checkup too of all of these things.
Yep. And we've actually came to appointments with our clients in your office previously.
You have.
And walked through this whole process with them.
Mm-hmm.
It's smooth, it's simple, it's a little emotional, I think, at times when you start thinking about it, but it's a very good process. So once again, phone number and website, please.
Sure. Phone number 319-753-6201. Website www.kozlawllc.com.
Perfect. All right. Todd, you want to add anything to this? You've
No,
been taking notes furiously.
I am. This is great. Yeah, I joke with Marvin. I'm one of your. I'm a person who's not following your advice at all. So I know that about myself, and we need to do something. But my kids were age. I think they were 8 and 4, and that's the will we still have in place. And they're now 32 and 27. So they're still going to their aunt.
Right.
As far as who gets possession of those kids.
Right.
And they don't really like that. So we need to get that cleaned up. But yeah, certainly things have changed in the last 25 years for our family. And I'm not really, I'm a plumber whose pipes leak. I'm into the financial planning side of things, but I'm not doing a good job with my own estate plan.
Well, and you brought up a great point. I know we're kind of towards the end, but as anyone who has minor children, you get to designate who's the guardian of those children should something happen to you. And that's a big driver. And I'm sorry I didn't bring that up sooner.
But if you don't, somebody's going to designate it.
Yeah.
That's right. So, yeah, it's super important. So, once again, estate planning seems to be an overlooked part of the financial planning process, whether it's the emotional piece, or the time piece, or the cost piece, whatever it is. But it's something you have to do. Because of what it means. It's just super crucial to have it in your life. So
through this process here today, I've seen a lot more links. And my background is not a whole career of financial planning. So this is it's been more individual to me, and my training is more an accountant, CPA type guy. But I see the ties a lot better between a financial plan and an estate plan. I mean, that one is a component of the other, and the other is a component of the other, and there are a lot of fingers that tie together there.
Sure. One thing, as I applaud people for coming in to see me and we develop their estate plan, I remind them, this isn't the last time you're going to see me. It's not like on the infomercials. It's not a set it and forget it kind of deal. Every 2 to 3 years, you're going to get a friendly reminder from me. Hey, let's take a look at this again and see if it still fits with what your life is now and what you want.
yeah, absolutely. So, well, as usual, my heartfelt thanks goes out to all of you for listening today. Special thanks to Joe Joel, Todd Sladky, and Mio Santiago for joining me today and providing their amazing feedback and information. Mio, we've already gone over how to get a hold of you, but if you want to throw one more plug out, let's make your time worthwhile.
Yeah, kozlawllc.com is the website. 319-753-6201.
We want to hear from you folks, so please reach out to me by giving me a call at 319-576-2264 or visiting our website at www.greatriverinvestments.com and going to the Contact Us section of the site. I or a member of my team may be in touch with you shortly to discuss our next steps together. Thank you again for listening to the Marvin Knows Finances show. This is Marvin Thomson, your certified financial planner. Have a great day.